Welcome back. I'm Samson Lardy Anyenini, and this is The Law. It's your legal light, and it is your health law. This afternoon, we are looking at the purpose of the procurement law. I'm sure for those of you tuned in, most of you will be asking, let's deal with single source procurement, which has become a bane of our economy. Much of the political corruption happens with single source procurement. Let's do a holistic education. We will get into that area as well. My guests in the studio, two foremost experts in the area of procurement law. Kobina Atabedu is here with us. Also here is Michael Kofi-Kwashie. Michael Kofi-Kwashie together with George Kojo Novisi Vuko-Kwashie are the authors of this book, An Appraisal of Ghana's Public Procurement Regime. And it's a must-have. You don't have to be someone in the procurement area to need this. It takes you through 360 of the law and more. So, as I said to you earlier, we have the very best to help us in this area. Thank you, gentlemen, for making the time to join us this afternoon. I suppose that for most of you, you are familiar with Kobina Atabedu, a procurement specialist and management consultant. And Michael, welcome.
Thank you.
Great. So, what is it that regulates or guides the area of procurement in Ghana?
Yeah, good afternoon first, Samson, and good afternoon to your listeners and viewers. And happy Father's Day to all the fathers.
Thank you. Happy Father's Day to all of you.
Yeah. Basically, the public procurement in Ghana is regulated by certain essential elements of laws, administrative regulations, rules, orders, and guidelines. All these together have been put out by government to control the process of public procurement in Ghana. So in sum, that is what regulates public procurement in Ghana.
Right. But we have the parent law, right, Kobina? We have the parent law. We decided in 2003 that we'll use that to anchor the process well.
Yeah.
What's your view of it?
From a legal perspective, it seems to have made very good provisions. But there's a difference between...
There's a but.
what is written, the interpretation that is given to what is written, and how it is applied. And the problem has been with the interpretation side and the how it is applied side. And these two together almost make this act moot and irrelevant, especially in these times.
So let's begin and write in your book An Appraisal of Ghana's Public Procurement Regime. You dedicate a chapter, that is chapter 3, to the objects of the Act. Yeah. That the Act is known as Act 663. And I have made a marking I want to quickly get to as far as discussing of the object of the law is concerned. You say, you and your friend George, coincidentally, both of you have Kwashie to your names. Are you related?
Yeah.
Oh, okay. So on the law, we are fortunate. The last time we had the two Atakores who have written the book on the sale of goods. Now, in chapter 3, you begin on the issue of object of Act 663, and you say that the object and aim of Act 663 is to ensure that public procurement in Ghana secures judicious, economic, and efficient use of state resources, and that procurement is carried out in a fair, transparent, non-discriminatory, environmentally and socially sustainable manner. That is a lot. Help us.
Yeah, basically what this seeks to do, the object and aim of this act seeks to do, is to ensure that there is value for money in public procurement. Because value for money, because money that is used for public procurement comes from the taxes you and I pay. In addition to that, whatever other resources we get from outside are things that are used for value for this procurement. And therefore, it is not for government to use the money anyhow. The public procurement entities are to ensure that that end, which is to secure judicious use of those funds, economic and efficient use, transcends the entire cycle of procurement that they undertake. This, in effect, is the cardinal point in public procurement. Any deviation from this will not ensure value for money. And when we talk of value for money, basically what we are saying is that this procurement should not be over-specified. For example, if we are to use the taxpayers' money to procure a vehicle that needs to be used for public duties, we shouldn't rush into just buying the high end of specification.
Shouldn't be luxury.
What is the minimum specification? Is this vehicle going to be used within Accra, for example? If it's going to be used within Accra, what should be the minimum specification in terms of the engine capacity of this vehicle? Is it going to be 1.8 liter engine? Yes, if it is, then we have no business buying a V8, for example, for this particular procurement. In effect, this is what we mean by securing judicious use of the taxpayers' money, where the law is concerned.
There's another dimension to value for money.
You find that in the Act, Section 2, it talks about the object of the board, which is actually what is translated here, about judicious, economic, efficient use of resources and ensuring transparency, non-discrimination. So is it the board's work or the law's work?
The board's job is to operationalize the law.
Right.
So they are supposed to make the decisions that would ensure the judicious use of funds. Now, the next paragraph talks about the definition of value for money.
Right.
Now, when we talk of value for money, it is not also just the economic elements. There's also the social element. And I can give you one example of value for money. And my mind goes back to a phrase President Kufuor made some time ago. He said that Ghanaians know the value, the cost of everything. But the value of nothing. Now, if you take something like...
And this was passed under his regime.
Under his regime, yes. It's one of the first things he did. And I always applaud him for doing this, actually. The circle interchange, the removal of the toll booths from Kaswa. Now, if you are doing a value for money assessment of that spend, the circle interchange, if you look at the amount of time people were spending in their cars, the amount of fuel we were burning waiting to cross that short distance, and the amount of pollution that we were doing to the environment, if you value the cost of that and you add it to the economic value of that construction, you'd see that eventually, from a value for money perspective, it's good to spend that money. Because by putting that there and freeing up the traffic in that space, look at the number of people who were cocked up there like for an hour trying to cross that short distance. And look at the productivity that we'll get from them if they are able to go about their duties as a nation and the impact on our GDP. So when you are doing value for money analysis, it's not just the price or the specification or what we will call the term the quality. Now, if we were doing all of that, he made a valid point. And when it comes to fleet, and I've had to do that in my private life,
Okay.
where I said to management that if you are telling me to cut cost in other areas, I don't see why you should use a high-end vehicle of an engine capacity of 5.7 liter. So the transport policy changes from today. It is going to be EXCO 3.0 liter engine, all operational vehicles 1.6 liter engines. And I did that in one place where I used to work, and by the time I was leaving, everybody was insulting me, but I couldn't care. But all operational vehicles 1.6 liter. In fact, I changed it to 1.3 because at that time Yaris had come. So I said, everybody gets a Yaris. Now, you can't do procurement law and leave Sale of Goods Act.
Okay.
So they go together. Now, in Sale of Goods Act, it will talk about fit for purpose. So then the first question you ask is this fit for purpose? So if the specification comes, and I always tell my procurement colleagues that, guys, you are not a stenographer secretary. A stenographer secretary is the person who takes a note with a pen.
Yeah.
And you dictate and he writes and he acts. Your job is to ensure judicious use of money. Your job is to give value. So what is requested is not sacrosanct. It's not cast in stone. It is for you to evaluate it. Is that fit for purpose? Most of the time, by the time a requirement comes to you, if you actually do what we call the onion principle, you peel the onion to the bud, and you want to look at what is the intrinsic need. What they're asking for does not need does not solve the problem they have. Something else will solve it.
Right.
And until you peel the onion to the bud, you won't understand the intrinsic need. So you won't be able to determine what is fit for purpose. That's what he just explained.
Michael, so you guys say that value for money, or the value you are talking about here for money, is not exactly about getting the goods at the lowest price. You say, so I'm reading here.
Yeah.
First, you say value for money refers to the best combination of cost, quality, and sustainability to meet a particular procurement requirement. The procurement must be made for the best goods, services, or works, and on the best terms possible. The prerequisite of value for money is achieved when public procurement is satisfied through a judicious, economic, effective, and efficient use of the state's resources. This is the point I'm coming to. Obviously, value for money does not necessarily mean procuring the goods, works, or services at the lowest price. It is rather aimed at achieving the following goals. Now, take us through that to understand what you mean, because our understanding value for money is that, like, Mr. Atabedu had just indicated, instead of a 4 liter or whatever vehicle, you will get a less. So you don't cost the company, you don't cost the state too much.
Yeah, Samson, thanks. You see, when we talk of the value for money in terms of best combination of costs, quality, and sustainability, as you said, it means what we want to meet. What is the barest minimum cost at which we can meet this requirement? It shouldn't be gold-plated. It should be the basic minimum, for the simple reason that you are using the taxpayers' money. And there are a lot of needs to be met in the country. So if you are going to start meeting specifications purely from a gold-plated perspective, then you will not be abiding by that requirement in Section 2 of judicious use of public funds. So you first look at what is the quality we are looking at here. The procurement people will say the characteristics and features that whatever requirement you want must possess in order to satisfy wants. In my earlier example, I mentioned within Accra, will you need a V8 or you need a sedan vehicle? If you will need a sedan vehicle to do that job, and that job is not for arduous long journeys, for example, then you must restrict yourself to the minimum requirement. And as we move along, you realize that when we talk of cost, we are not even allowed in Assistance 3, specifically Section 33.2, for you to even be branch specific. You can't say, I want a SUV of a particular make. No, the Act does not permit that. You must give the minimum requirement in order to satisfy the want. And if you look at the various provisions in this Act very well, it all centers around these objects. Okay? That is how come it will tell you, for example, you cannot just stand up and specify any brand you want. In a situation where you don't have the specific details of that brand and of what you want, and therefore there's only a particular brand you are going to use, the Act even says you must indicate that or the equivalent of that brand. All this is geared towards ensuring that there is judicious use of the taxpayers' money.
And there's competition.
And there is
Competition.
competition.
Sure.
Because if you take a vehicle, let's use a vehicle for example, the basic definitions of a vehicle would be with an engine capacity of X, with either manual transmission or automatic transmission, 2 doors or 4 doors or 5 doors, power steering, power windows, power locks, and all that.
That's specifications.
Specifications, yes. You must specify. Now, there are specific vehicles that have unique specification. So if you say a crossover or an SUV with a 3.5-liter engine, you get only 1 or 2 cars which are at the level of a crossover. Because a crossover is smaller, but has a bigger engine capacity.
That's right.
And as soon as you do that, you have skewed it to one person. And so it will take out everybody. So in situations like that, you give a range between 2.8 liter and 3.5 liter. So that an equivalent, which is not 3.5 liter, but 2.8 liter, qualifies.
So over here, you are working to achieve what Section 2 requires by saying it should be non-discriminatory and it should be fair.
Yes.
Sure. All right.
That's why I said that the law, and I always will stand up for one person who ensured that this law was written the way it was written.
Who's that?
And that's Mr. Besam,
Okay.
the first chairman of the board. He's an engineer of long-standing practice in procurement.
That explains
In highways.
the plenty technicality and specification to detail
Yes.
in the law.
Yes.
All right.
He is the architect. He has done this country a good service by making sure it is written like this.
All right.
Now, there's something else that I want to say. Unfortunately, we don't have a projection here, but you can see from here.
Okay.
There's a misconception about procurement. And procurement is basically acquisition through any means, any legal means possible. So buying, which is paying to acquire something, is only one option. Now, when we come to value for money, take an economy that is struggling. Everything we acquire, we pay to acquire. So you need a huge capital outlay to be able to do that, especially when it comes to what we in accounting we call CAPEX, capital expenditure. Now, you can acquire capital expenditure through other means, not necessarily buying, paying upfront to acquire them. Leasing is an option where you get to acquire it and you match the repayments to your cash flow. Now, leasing allows you to use the asset over a longer period of time. Renting allows you to do same, but use it over a shorter period of time. So some of the acquisitions we make, should we actually buy them or rent them? So you find out that sometimes we buy an asset, we use it for a short purpose, and it is sitting down doing nothing, wasting away, become a white elephant. We shouldn't have bought it.
So
Then there's hiring for a few hours or a few days. Then there's the option of no expenditure having to be spent, but the need being fulfilled.
hey, how is that possible?
Good. Now, I use it as a case study when I'm lecturing. And I would ask my class to assess and tell me what is the best means. So, for example, we have a crisis in an area. We are in the rains. So there's been a rain, a bridge has been washed away, or a feeder road has been washed away, so the road has become impassable. You need the services of an excavator and a motor grader to make the road passable. Should we buy, or should we lease, or should we rent?
Make or buy.
Or can we get to fulfill this without spending
What
money?
did you just say?
Make or
It's
buy.
called make or
Make
buy.
or buy.
Make or buy.
But in either situation, it doesn't,
I'm coming to that.
it will still require expenditure.
You may not have to expend, because if you look at that district, you may find that in that district, there is already a mobilized contractor working somewhere who you have paid for the use of the services of a motor grader and an excavator. You can commandeer that for a day or two and use it to repair this one and go back to your job. You don't have to pay for it. It can be done.
But that will be extra work. So the contractor will require being paid for that extra work, which was not anticipated.
No, it depends on if you look at his project plan and the critical path for that project. He may not be using those at that particular time, but they are mobilized on site. So you can commandeer it. So the context.
If it is fuel that they need to spend, it's already been paid for. If it is some concrete that they require, they already have it on site. That's what you're saying.
So you can commandeer it and use it, and you don't have to spend. So there's a degree of risk associated with each of them.
All right.
Buying has the highest level of risk, but not paying anything has the least of risks. And it is the job of the procurement people. And so if I take you to chapter 1 of the book, second paragraph, last sentence, the directly related procurement activities undertaken by a procurement entity include procurement planning, invitation for offers from suppliers, contractors, evaluation of offers, award. This is the first weakness of the Act, because it fails to add the science part of procurement to it. It defines a process, and I'll show you from here.
You're here on The Law. This is your legal light. It is your help law. And we are privileged to be in the procurement law classroom. And this is beyond law, actually, because there's a lot that these experts here will take us through that you don't find in the law, but it is necessary to understanding the law. We are dealing with purpose of the procurement law. And my guests here are Michael Kofi Kwashi and Kobina Atta Bedu. Just a while ago, we put up the section 2 of the Act for you to follow. And we're trying preliminarily, as we begin the discussion, to get to appreciate the exact purpose of the law and if in the implementation we are achieving it at all. Yes, you are going to make a point there.
Yes. So there's something we call category management, and it's a process, a cycle. Now, if you look at, and that is how we drive value, using the category management process. Now, if you look at how we do our procurement, as has been defined by the Act, it starts with procurement planning, which is business needs analysis and specification, definition. Now, as soon as we define what we want, we get into the mood for tendering. And then we go into an award, and then we are executing, and it ends there. But there are two critical steps if you are running a category management cycle. The next step after defining what you need is a supply market analysis, where you are going into the market. You are going to find out who does what, how do they do it, what models are they even applying. So what model can I apply? How have I done it in the past and how can I do it now? And after evaluating the market, the next step is to formulate your strategy that will give you the value for money.
All right.
Now, these two critical steps, which are the value drivers, are out of our procurement process. Because the Act doesn't require anybody to do that kind of assessment. So I have a 25
But the Act has this monitoring aspects and processes. That's after the contracting is added.
Monitoring is post facto.
Okay. So let me bring Michael in.
Yeah.
You wanted to say something about this? Yes.
Yeah, I'm saying that, yes, it's not, yes, I agree with Kobna to a large extent, but you know what the Act has seen to cure this is to make sure that big ticket procurements, you first need to do what we call pre-qualification. And pre-qualification means you are going to do an assessment of potential suppliers to see who has got the capability and capacity to do this job before you even invite them to submit tenders. So you are going to start from a position of, we are inviting applications for this particular thing.
All right.
I think it's been looked at, pre-qualification has been looked at in chapter 4.
Great. Now I need us to take our audiences along.
Okay.
So now that we have looked around the purpose of the law and we have highlighted the Lord's command and requirement for public procurement that secures judicious, economic, and efficient use of state resources, and also that this must be carried out in a fair, transparent, and non-discriminatory, environmentally and socially sustainable manner, let's go to see how we go about the procurement in the first place. What are the methods that we get into when we are procuring goods and services?
Okay, yeah, thanks, Samson. And
Right.
that is looked at in chapter 5
That's correct.
of the book. Apparently, there are 12 procurement methods in this law. It's just that because two are very sensitive, there are single source and restricted tendering. So
Right.
more often than not, we tend to over-focus on single source and restricted tendering.
Right.
But in reality, there are 12 different procurement methods, and all have been catered for in this book. That's why
But under the 12,
it must
you
have-
have dealt with them under a 4 broad
certainly.
categories.
Certainly.
Okay. So
And
what are these methods?
And the first is, I must emphasize that the Act actually provides that we use competitive tendering as the default method.
Competitive tendering.
And within competitive tendering are 5 different modes of tendering. We have what we call the national competitive tender, where within the Act, any procurement you are going to make above a certain threshold or within a certain threshold, you have to use the national competitive tender. And this has been deliberately made in such a way that is to encourage as much local participation as possible. So that procurement is restricted to businesses in the jurisdiction.
Okay.
But there could be instances where there is a foreign company that has a local agent who could also participate in this. Then we have the international competitive tendering, which means that we are now opening this tender outside to the whole world, and therefore not restricted only to the nation called Ghana. So unlike the first one, which is national competitive tendering, this is international competitive tendering. Then, but that also comes within after a certain threshold. That's if you cannot get people locally who have what it takes to do this job, for example, then you look at the international competitive tendering. Then we have what we call the two-stage tendering. Two-stage tendering is a very interesting procurement method. What happens here is, let's say you want to procure something, you are not too clear about the specification. for the sake of this discussion, let's say we want to build a dam, which could give us, currently with our energy challenges, we want to build a dam that's maybe 500 megawatts. But at the same time, and it's a hydro dam, in the sense that it's going to use water.
Right.
But at the same time, we want to also benefit from farming. So we are saying we want to come out with a dam that can generate 500 megawatts of electricity for the country, but at the same time can be used for irrigation purposes. This is a bit of a complicated thing.
Yeah.
So
that's the sort of idea we have conceived for the Polgu multipurpose dam.
Exactly. Fantastic. So in this case, you may have an idea of the specifications you want, but you may not be too clear. You may feel the market has, in terms of technology, for example, the market has something more.
So in this light, there are two kinds of specifications. You have a conformance specification and a performance specification.
Okay.
So you end up starting off with a performance specification, which gives you an end.
Okay.
This is what I want to achieve as an end.
Yeah.
You don't know how to get there. So you use this method to start a process of getting information which will lead you to the end you are trying to get.
Performance.
Okay, that's right. So once you go to the market and say, this is what we want to do, like he said, and this is what we are thinking, if you also are interested in this, give us how you think this should be done. Then you have people putting in their tenders. At this point, nobody's going to quote for price.
Okay.
It's just going to give you the solutions. And then where they agree with what you've said, they will stay so in their tender. Where they don't agree, they'll say, this is what we think. You look at that, in evaluating these tenders, you separate the, excuse my French, the wheat from the chaff.
That's right.
So then you zero in on those who have offered a solution that quite ties in with what you are looking for. And these are people you are now going to zero in on one specification and then use that to invite everybody to now quote for this job.
All right, that's the two-stage.
Two-stage.
So what next?
Then you also have the restricted tendering, your favorite restricted tendering, where you are saying that, yes, this thing is, one, maybe it's a very complicated requirement. It's only few people who deal in this. So you need to invite those few entities to quote for this. They are restricted, unlike the first two, the national, international. Or you could also say that looking at the value of this procurement, if we are to advertise this, the number of people who put in the requests at the end of the day will far exceed the value of what we are looking for. And don't forget, once more, your Section 2, judicious use. So in this case, if you have to do that, it will make the procurement very expensive. So rather, we will restrict to some people we know have the capability and capacity to do this. That is another scenario. Or you might have advertised the procurement and barely got anybody to respond to this. And yet, you know, there are some few entities out there who have what it takes to do this.
All right.
Then you can decide that we are going to use this method and get in touch with them to quote for this. So that is how you use the restricted tendering.
Right.
And that has been provided for by Section 38 and 39
right.
of Access
In your,
then you have the request for quotation method, where with request for quotation, the value is not that big for this procurement. So you just pick
Low
some
value, high volume.
Yeah, to do this.
Right. Now, in your practice, not in your teaching, which of these methods should be ideal, if I can ask that question?
Good.
Competitive tendering.
So in practice, there's a model we use. We use it for two things. To situate the type of item you are buying and the kind of relationship you should build with the supplier of that item. It's called the Kralich model. It's a quadrant. Now, on the y-axis is the value. On the x-axis is your degree of risk. So where the value is high and you have a high degree of risk, normally it is because it is strategic. We call it strategic. It is proprietary. There are only one or probably two who can. So if you want office application for your laptops, you buy a laptop, there's no software. You need software to use. Everybody is using Microsoft Office. So if you want to acquire a Microsoft Office suite, you are likely to deal with only the Microsoft organization. In that case, the model tells you that you are looking here at potentially a single source, dealing with Microsoft. You can, however, diffuse that, because the objective of every procurement person when you are managing risk is to diffuse your risk. So rather than be reliant or dependent on one entity, your intention is to move it this way to where there's a less degree of risk. You can decide that I'm going to go through a Microsoft partner, their distribution agent, partners, and that opens them up for competition, so you can get them to pitch. But the trick here is that they will all end up with Microsoft. So you might, if you want value for money, build a relationship with Microsoft. So then you begin to position yourself to build a relationship with Microsoft, so you can acquire directly from them. Then, if you come down, so on a high risk side, if your spend is less, you are likely to find that there are only 1 or 2 or 3 people. So it's more of a duopoly or an oligopolistic market. How do you manage that? The prescription is that in situations like that, you are using relationships to secure your contracts for a short to medium term period, whilst you work towards developing other sources to bring in more competition. But the default in all of this is to make sure that you are always engendering competition. So it's a leverage item, where you use competitive tendering to force market to bring the price down. So on that side, your risk has been diffused already through competition, and you are using that competition to bring the price down. So if you look at the quadrant, everything you are doing is aiming at bringing everybody to that small box on the left-hand side, which is called the nuisance. And it even makes provision for that here, that where you have such low-value, high-volume transactions, which are usually we call a nuisance, you don't do tender every day. You secure them with frame agreements. So like for stationery, where we are buying A4 sheets, we are buying on a daily basis, we are using high volumes, but the value of it is insignificant. You don't need to do a tender every day, because there's also what we call the transactional cost of procurement. If I have to buy a car today, how much will it cost for me to go through a tender, advertise it, spend all this to do it? And if you have to do this every month, you look at the cost of the transaction itself, and you realize that it doesn't match even the budget you are
Michael
spending for that.
mentioned that earlier.
Exactly. So you do a frame agreement for, let's say, 3 years, lock the prices in. If you have to put in a price escalation clause or a price variation clause because of the model of pricing, you put all those in and put it down and leave it to run. Then you focus on other high value things that you have a high risk on, that your objective is to diffuse the risk all the time.
Yeah, so framework agreement has also been looked at.
Yes. I find that framework agreement, you treat that as the fourth, under which you have all the other things you want to treat as far as your, 12 different methods are concerned. Because you treat under competitive tendering, single source procurement, selection of consultants, and framework agreement. Now, the question I asked, which brought in Atabedu, was the ideal of the methods.
Competitive.
He said competitive.
The act says
you also say competitive.
I say competitive, yes.
Okay. In section 34, it says competitive is the best approach.
Yeah, 35.1.
35.1.
Yeah.
Okay.
That's the default.
Why does he say so? Start with you and come to him.
You see, if you don't do competitive and you do single sourcing, it means you are building a strategic relationship, but it means you are dependent on a vendor. Now, in risk management, we would say that if your business depends 80%, or you spend 80% of your budget on only, you are likely to spend 80% of your budget on 20% of your supplier base. That means you are heavily reliant on a few people. Now, when you have a situation like that, you have to be following those businesses on a day-to-day basis. What happens there, what their books look like. Because if they go bust today, your business is gone. So, I don't know how. See, I'll give an example. Today, I read in the news that a cable TV network, popular across Africa, is in serious trouble.
Yeah.
Dire straits.
That's right.
And is likely to go down. Assuming I have a business that relies on their services to generate my revenues, it means if they go down tomorrow morning, my business is gone.
That's right.
Because I am 100% reliant on that business. Meanwhile, I don't have any control over the decisions that are being made there to ensure that they are liquid. So I carry a risk, and it is incumbent on me, and by extension, my board, to ensure that I diffuse it by ensuring that I have relationship with other cable TV networks, that any day that this one shuts down, I can switch this one on and move on. So your objective in a strategic relationship, you go that way because you don't have a choice. But if you have a choice, you take it in the short to medium term and you develop alternatives. Restricted tendering in the Act cures that by ensuring that you have 2 or 3 of them that you can knock their heads together to secure that short-term relief. But the ultimate objective is to always ensure that you have a plethora of supplies you can play with. So your hands will not be tied to one person.
Right.
And you will not be screwed.
Right. What do we mean when we say competitive tendering? And in Section 35, I think, as you referred me to, no, in Section 34 rather.
Okay.
In Section 34.8, it speaks about the methods. And in 34AA, it says competitive tendering, that includes international competitive tendering, national competitive tendering, request for quotations, and restricted tendering. You have just spoken to this. What do we mean when we say competitive procurement method?
See, when we talk of competitive tendering, I'm taking you back to Section 2.
Okay.
Transparency, non-discrimination.
All right. Fairness.
Fairness. Okay. That's why I keep on telling you that this whole act, the regulation of public procurement in Ghana, is centered around Section 2. You will never go wrong if you abide religiously by Section 2. Because and in the book, if you wouldn't mind me referring you to the book.
Go ahead.
If you look at page 82, that's 2.6, I said, competitive tendering, the default procurement method.
All right.
Okay. And yes, I do agree that experts have talked of how people could even manipulate the system. I agree. And its advantages and disadvantages. But what we said is that in spite of the possibility, okay, of certain corrupt activities posing risk to the utilization of the competitive tendering method, we submit that the enforceability of clear rules with respect to the method, such as advertising the procurement opportunity in the newspaper of wide circulation, and making the evaluation criteria publicly known in the tender documents, among other things, ensures maximum competition.
Right.
And Kobina has already told you of what you tend to gain if you maximize competition.
Okay.
Hence, I will say in sum, this is the reason why competitive tendering is the default procurement.
Yes, and you say that competitive tendering method is often accepted as part and parcel of the transparency element in public procurement.
Exactly. Samson.
Is that what most public institutions, is that the method most public institutions adopt, from what you know?
Yeah, for what I know, that is the method the Act requires as the default, and it's actually governed by certain thresholds, and that is what public institutions are supposed to abide by. And in reality, that is what is expected of them. If for whatever reason they don't abide by this, then they have a price to pay.
It's a contravention.
Seriously.
Now,
because this act is not just a mere statement of intent.
I started off by saying that there's what is written, and there's the interpretation of it, and there's the what happens. Now, the interpretation of it is, okay, we are supposed to advertise, so we've advertised. So it's like ticking the box. We are supposed to sell tender documents. So we've sold the tender documents. But the tender documents have been bought. Who bought them? 5 different companies have come. So you have received bids from 5 different companies. So there's a semblance of competition. But if you should go into the corporate law elements of it and begin to pick the companies and do the due diligence on the companies, do the pre-qualification of the companies, take the Companies Act, go and see who are the beneficial owners, you find out that you get to the point where you are seeing that all 5 companies are pointing to one person. That is ringing. That is tender rigging. And that takes away competition. But that kind of activity cannot be regulated with law. It is the people who run the process who must do their job and be vigilant to identify that and weed it out. So
we made this law in 2003 and made the regulations in 2022.
2022, yeah.
2022.
Yeah, L1.
So I'm wondering, why did it take us that long? And when we got to that point in the regulations, we couldn't cure this problem. Or your point is that law cannot cure that problem.
Law cannot cure that problem. It is morality. It is ethics and integrity that will cure that problem.
So from your practice, what you know, is it really the case that the best and what the authors say is the default competitive tendering is what public entities apply in buying goods and services? Is that what you know?
No. That's not what pertains.
Oh, really?
Yes.
No, I think that's a difficult question for you. So I went to him. But please proceed. What do you want to say?
No, all that I want to say is that, this is a law. It's not a mere statement of intent. Okay. And as a public entity, like I said, it's the taxpayers' money. Okay,
we understand that you are itching to call us even before we announce the phone line. So you can call. We can pick a few calls, but we will narrow in to single source procurement and the problems with it that this country is having to pay hugely for. Dr. Kangston, you are calling us from right here in Accra. Hi, Doc. Let's hear you.
Something and the panel, my senior colleague. But Kwabena was my boss at Vodafone.
Oh, wow.
I just want to collaborate the point that Kwabena was making.
Okay.
And somehow I think he left it midway because sort of project. So Kwabena was going into a very important area that has been of interest to me of late. When you pick the Auditor General report and try to go into it, where you see that there is a semblance of a competitive tender having been initiated. You have proposals of this on the market. Now, when you get this proposal as part of the qualification criteria, in line with the evaluation processes that you would like to subject the proposals to, it is important that you go behind the submissions in line with the corporate law to see who are the original beneficiaries of these entities that have submitted proposals. There are instances where you receive proposals from about, say, 5 or 7 suppliers participating in a supposed competitive tender. And it turned out that Company A, you go to the Form 3, you realize that the beneficiaries or the shareholding structure are also entities. Okay? The question is, you need to go further to reveal, take off the veil. Who are the owners of these beneficiaries who are also entities? By the time you finish this exercise, it will turn out that out of the 7 suppliers that actually submitted proposals in response to the tender, the directors are the same for almost all the 5 suppliers that submitted proposals. So these incidents occur, especially where we have people who have been given prior notice of a tender coming, they prep in advance, the tender notification period is very short. I don't want to give instances of where a tender has been issued in less than, even though supposedly advertised either online or in a widely circulated media outlet. The announcement period is very, very short. So only a few people will get notice or have the capacity to actually respond.
All right.
Because it takes a lot of effort
Okay.
to actually prep a response to a tender and
Okay.
effect a submission.
All right.
So in itself, you are actually deliberately restricting, or in a subtle manner, the seemingly restricting competitiveness. And these are some of the things that are actually affecting us as a country.
All right, Dr. Kangson, thank you so very much. Unfortunately, we just ran out of time. We cannot continue to pick any more calls. So I will take very quick final comments on what the solution should be to defeat this problem. And then in our second installment, the part 2, we will focus on single source and why it brings so much problems to this country. Yes, beginning with you.
Yeah, you know, like I said, I'm going back to my point that it's an issue of enforceability of what is in the law. The caller said people could just give a very short time period for this. And
Yeah, they will beat the system.
But the issue is, if you look into the acts, national competitive tender, for example, you are supposed to give 14 days notice. With international competitive tender, you could go about 6 weeks. So if you are going to conduct this tender and you do it within 3 days, it means you are breaching the law. That is why I'm talking about making sure that people comply with the law, and if they don't comply, they pay the penalty for breaching the law. I believe it is when we start doing that, then we'll get people's attention for them to really comply with the law. But if not, and it's business as usual,
Is he suggesting that the kind of tendering or advertisement is hidden somewhat, or that they actually don't comply with the 14 days?
Listening to him, he said some don't. And I'm saying if they don't, then they are breaching the law.
Okay. Yes, Governor.
So, first point he made was, if there's no punitive measures, it's called behavior reinforcement. If you don't reinforce behavior in the direction you want, people will abuse it. So you must do that. The second thing is that whilst the letter of this is trying to set out a process, in actual fact, the process should now be moved from offline to an online system, an ERP. So currently, our ERP, for example, for financial management is an Oracle system, GIFMIS. It's time that we move to the procurement module of that system,
Right.
which would ensure that people will have to follow the steps. And if you don't do step A, you can't go to step B.
Thank you very much, Kwabena Atabedu and Michael Kofi Kwashi, procurement experts who have been helping us to understand Ghana's procurement law and its purpose. And this has been The Law. It's your legal light. It's your health law. Catch us on part 2 of this discussion as we focus on single source procurement and the problems it brings to this country, how that can be resolved. I'm Samson Lardy Anyenini. Have a good afternoon.